Attorney Don Harris in Albuquerque, New Mexico. Learn about child custody laws in this video. You may be a parent in New Mexico going through a divorce. Maybe you're no longer married to your former partner, but have children together. Your relationship may have ended years ago, and the custody agreement was working for a while, but now it is not, and you know that things need to change. Technically speaking, custody is the legal right to make decisions for a child. It is possible that someone in prison could have joint legal custody with a child he almost never sees. That just means the mother would have to discuss with the father whether his daughter, for example, should go to private school, take ballet lessons, or have braces. Joint custody means parents make decisions together. Sole custody means one parent makes the decisions. There can be hybrid arrangements where one parent has sole custody on medical decisions and the other has sole custody on some other issue, perhaps education or extracurricular activities. Occasionally, parents can have equal time with the child, but one parent has sole custody because the parents are simply unable to get along and make decisions together, so the court awards decision-making to one parent or the other to stop the conflict. Joint custody is the presumption in New Mexico, meaning the New Mexico family law judge will start with the opinion that joint custody will be awarded unless someone can prove otherwise, that sole custody would be best for the child. Unless there is some significant issue with one of the parties' ability to be a parent, or unless there is an inability for the parties to reach agreements together, joint custody will likely be awarded. Time sharing is a concept that attempts to respect both parents' role in raising a child. The goal is that no parent is the primary custodian, with the other parent having mere visitation. One parent has more time, or as some lawyers put it, is on duty more often than the other parent. Modern thinking about raising children by divorced parents is that one parent should not be viewed as the custodial parent and the other parent having visitation. Both parents, ideally, should have a meaningful relationship with the child for the child to develop properly and fully, and they both should have equally important roles, even if one is on duty more often. That belief, that both parents are equally important to a child, even if one has more time than the other, helps to clarify how judges look at time-sharing disputes, what parents call custody battles, differently than parents. The courts are focused on one thing only when a time-sharing dispute arises: what is in the best interest of the child. The same issue is, of course, what matters when there is a dispute regarding sole custody versus joint custody. You may have tried to reach an agreement with your child's other parent, but repeatedly hit a wall. Perhaps the other parent simply wants too much time, wants to significantly diminish your role, or the other parent wants time when they cannot even be with the child. Alternatively, perhaps you cannot go along with what the other parent desires because the other parent is irresponsible or engages in dangerous or unhealthy behaviors, or harms the child emotionally or even physically. If you are in this situation, it is very appropriate to ask a court to assist you because you cannot agree with your child's other parent about time sharing or custody. Further, you know that allowing the other parent to have his or her way would be harmful to the child. You have a custody battle. Dealing with custody or timeshare disputes is difficult for the courts because both parents are highly emotional and the children cannot testify. The courts use third-party professionals to assist in these disputes. Under New Mexico law, courts have 4 different types of third-party professionals they can bring in to resolve custody disputes: a mediator, a guardian ad litem, a court-appointed expert witness, and a special master. I will not discuss the final option, a special master, because it is not used very often. The other 3 are quite common, and I will discuss them very briefly. A mediator works with the parties to try to get them to agree on parenting arrangements. The courts believe the best outcome is usually one the parties choose themselves. This is especially true because it helps reduce the stress and future uncertainty of potentially going back to court. Solutions that are imposed on parents are more likely to be resisted and challenged in the future. A guardian ad litem, or GAL, is a lawyer that has been appointed for the child. Usually the parents share the cost of the GAL. This GAL interviews the parents, the child, and other important people in the child's life: teachers, counselors, and often other family or friends. The GAL then makes a recommendation to the court. A court-appointed expert witness is usually a clinical or child psychologist who will do a more detailed examination of the situation, including not only meetings but often psychological testing and a more in-depth analysis of the child, the parents, and the living situation. In New Mexico, a court will not have a child testify. However, a judge can interview a child privately in their office. These conversations are not made public. Normally, a judge will only speak privately with an older child, usually a teenager. If you can work out your custody dispute with the other parent in a way that benefits the child, you should. Often, that is simply not possible. The well-being and healthy development of the child is likely one of the greatest, if not the greatest, concern of most parents. If you are going through a difficult custody battle, you should consult with a family law attorney. Call attorney Don Harris in Albuquerque to answer your questions about child custody in New Mexico.